Hello, I'm Michael Brock at Brock Counseling and Evaluation Services. And today we are going to talk about Chapter 5 in the book that I wrote with Matthew Zeck called Get Your Michigan Driver's License Back. This book tells you everything you need to know to get your license back if you have lost it from drinking and driving or drugging and driving. Chapter 5 primarily is addressed to attorneys, and it's called Application of Rule 13 at the hearing. When Matt goes to a hearing for one of our clients that I've done an evaluation for, he likes to bring out and read a copy of Rule 257.313, also known as Rule 13, at the hearing, which are the standards for issuing a license. They require the petitioner to prove 5 points. And Matt likes to go through each of the 5 points. The reason for this being that the information is all in the evaluation, but it is in mental health language rather than in attorney language. And he likes to correlate what the evaluation says with the law to show that each of the points has been made. The first point is that petitioner's alcohol or substance abuse problem, if any, is under control. And this factor is covered in the diagnosis and includes information from the Michigan Substance Abuse Screening Test regarding tolerance and frequency of use, severity of abuse dependence, and length of absence. The client's length of sobriety absence from alcohol, illicit drugs, and/or abuse of prescription medications, if more than 1 year, constitutes a diagnosis of substance dependence in sustained full remission. And anything less than sustained full remission is probably not going to result in being awarded a license. And it's crucial in the diagnosis that all substances of abuse are addressed. This means illicit drugs as well as legal drugs that the client may have been inclined to abuse, such as benzodiazepines or opiates. Pain medications are quite commonly abused today, and in fact there are more deaths each year from abuse of legal opiates than there is from abuse of cocaine and heroin. So it's important that you address these factors. If your client is taking a medication, then you're going to need a DI-4P from a doctor stating why he needs to be on these meds and that they will not impede his ability to drive safely. This is also true of mental health diagnoses, which need to be included as well, and any medications that they're taking for mental health issues, if there's a possibility that those issues may lead the client back to abusing substances in order to obtain relief, say from depression. So you want to make sure that you address all drugs of abuse and all mental health and substance abuse conditions. Number 2 is the risk of the petitioner repeating his past abusive behavior is a low or minimal risk. This information is covered primarily in the prognosis, including the reasons the client is a excellent, good, fair, poor, or guided risk for relapse. Now realistically, your client is going to have an excellent or good prognosis in order to get a license back. If he's fair or guarded, this is not clear and convincing evidence, and the law states that he must have clear and convincing evidence in order to be awarded a license. When we're doing an evaluation, we like to have the client give a narrative of all the ways in which their life has changed for the better. And in general, if the person seems to have a better life and a more satisfying, gratifying life sober than they had when they were drinking, and they can point to successes such as better relationships, more money in their pocket, better job, and just an overall sense of well-being and an appreciation for the fact that they are better off sober, then we feel that they present a good risk to remain abstinent and to obey the laws and to drive safely. Number 3 is the risk of the petitioner repeating the act of drinking and driving or drugging and driving is low or minimal. Some substance abusers and addicts think that they will be able to continue drinking or drugging and using substances, but they will simply refrain from using while they're driving. However, even if most of the time they're able to get someone else to drive while they are drinking or when they've been taking drugs, inevitably the time comes when no one is available and they need to get from where they are to someplace else, and they get behind the wheel with predictable results. So it is very important to make it very clear to the hearing officer that the client knows that he is expected to remain abstinent permanently. And this is important even for AA members, because sometimes AA members will say something to the effect of, well, I stay sober one day at a time. Well, that's wonderful that you stay sober one day at a time, but the hearing officer expects you to stay sober permanently, so you can't tell him, my sobriety is only as good as this day. He wants more assurance than that. He wants the belief that your intention and the probability is that your client will remain sober permanently and will never present a risk behind the wheel to himself or others. Point number 4 is the petitioner has the ability and motivation to drive safely and within the law. At this point, Matt will bring out whether or not there are any 904 sanctions. These are citations for the person driving without a license when their license has been suspended or revoked. If the person has obeyed the law and does not have any arrests, it is important to point that out, because it shows that they are obeying the law when they don't have a license. Therefore, they're more likely to obey the law when they do have a license. If they have driven without a license and have been arrested for that, if it has been a long time, then it's a good thing. If it has been a relatively short time, then you're going to have more problems. And in fact, as you know, generally the person's license is suspended for an additional year or up to 5 years in some cases if they are caught driving without a license. So driving without a license is a bad idea, and it's very important that you seek to get your license back, or that your client seeks to get his license back before he runs into the situation, which will make it harder. Another thing is that we often run into cases where a person comes to us after they've been arrested for driving unsuspended, and unless that case can be reduced to a non-abstractable offense, they will not be eligible to get their license back, even if they have an evaluation. Some judges, however, will reduce these cases to a non-abstractable offense, and an attorney can look into that. But something even like driving without an operator's license, or anything that puts the driver, the client, behind the wheel, is going to be a problem, and is going to result in either denial of a license at the hearing, or when that case actually gets abstracted onto the person's driver's license, it will be immediately, his current license will be immediately revoked. So it's very important to be clear with your clients about this, and also to know what your options are as an attorney. If you'd like to know more about that, you might want to call Matthew Zick at Grunow and Associates in Flat Rock. Okay, point number 5 is other showings that are relevant to the issues identified in paragraphs 1 through 4. Matt says that the 10-panel drug screen with integrity variables is extremely important at the hearing. Sometimes people want to bring in drug screens that don't have 10 drugs, that test for 5 drugs or 8 drugs, and frequently I have clients tell me, well, I can get my drug screen through my doctor, or I can get it over here or somewhere else, that they think they're going to save $50, which is what I charge for a drug screen. And usually they pay more than what I charge, and it doesn't have the necessary integrity variables. Integrity variables are things like creatinine specific gravity, pH level, things that test as to whether or not the urine has been tampered with and whether or not it's concentrated enough to provide a valid sample. Hearing officers are sticklers about this. They do not like to see a sample with a creatinine level below 20. They don't have any confidence in it. It is technically low, and I have seen people denied because they refuse to redo a test. And incidentally, the creatinine level is the most common problem that I find in testing. Most people do not come into an evaluation after they've been using heroin and they're going to test positive for opiates. Typically the problem we have is that they drank too much water and their urine is too dilute. And even though I know that these people are clean and sober, I ask them to come back in because there's no point in going in there with less than the best evidence. So it's important to have a good drug screen. Matt is a stickler for accurate dates on the evaluation whenever they can be obtained. He also likes to have the driving record before the evaluation is complete, because sometimes clients will omit an MIP or a marijuana arrest inadvertently. And these days everything has to be, any offense that had anything to do with substances has to be on the evaluation. I've had clients argue with me about this and say, you know, that's irrelevant that I got an MIP when I was a kid, or it's irrelevant that I got busted for drug trafficking or whatever it was because I wasn't using it at the time. And these things are on the client's criminal record, and most of the time they're on the driving record. And the hearing officer will have both of those, and the law is the law. The law says that you have to have these, and anything that's omitted from the evaluation will be perceived as being the client not being candid, not being honest. And if the hearing officer doesn't think your client's being honest, there's no way he's going to give him a license. Now, Matt also discourages clients from picking their own substance abuse evaluators because, in Matt's words, and I'm quoting, in the vast majority of cases are won and lost before you ever sit down at the hearing. If there are contradictions between the record and what the client told the evaluator, it's going to look like the client has not been forthcoming, and there is very little a lawyer can do to alter that impression. So, again, they're asking you the same information 4 times: the evaluation, the request for hearing that the client fills out, the letters of support, and at the hearing itself. And if everything does not line up, then it's going to be a problem. But if you are honest and forthcoming, and you've looked over the evidence before you go to the hearing, and your client knows what's in the reports, then you are more apt to be successful. Thank you.